my tax aspect, and I've got a lawyer who helped me do it. Okay, so now I call that lawyer. Hey, my son's, just had my computers seized because he's caught up in something, whatever it is. Is that lawyer going to know what to do? Is he going to be smart enough to say, this ain't my field, which ethically, lawyers, I can only take a case that I'm competent to take, or I have enough time to get competent to do the research and the representation on that. So, again, people like everybody else. Is that lawyer going to say, I'm going to go find a referral for someone who knows what they're doing in this area, or am I going to do the research? So you're taking out a whole aspects of whether mom and pop and large company are going to have the same resources. Typically, attorney knows what he's doing, going to be able to cite, hey, I've got a business here, they've got to get it back, work with the prosecutors to image it, to get that back. I mean, these are all the things that you're going to be doing for your client to get it back.
Let's say your hard drive got seized by the government, but you had hard drive encryption on it. Can you not give your password to the government under self-discrimination?
All right, so the question is, I've got a hard drive, it's encrypted, and can I give the password to the government? Can you not give it under self-incrimination? So, well, let's go through the facts. I've got your hard drive, it's encrypted. What's the password? Do you think that there's a violation of the Fifth Amendment right there? I would say yes. At that point in time, you have the right to remain silent. They see whether you have the ability is the next question. a lot of there's been some great cases in here jumping ahead on consent and aspects on whether when police are right there. There's a case in revoking consent where they're investigating child porn. They contact the guy. Hey, come on in and talk to us. And so the guy does. Mistake one. But he calls back and he says, oh, the computer you want to see? Oh, God, I reformatted it, so I wiped it clean. Well, come on in and talk anyways. So he does. So, and through the conversation, they're like, well, can we go to your place and get the computer? And the guy does. And as they're leaving to go, he signs a consent form for the search. And he says, I'm not sure. What's the penalty if I get caught up on all this? Because there might be something on there. And they kind of, tell him what the range could be, but, they're not lawyers, and if you want to revoke consent, you can. And he goes, oh, no, not now. And they drive over to another agent's office to pick up this other agent to go to his house. And even, when they stop there, he goes, oh, I think I may not want to consent. And the guy's like, well, think about it, and when we get to your house, you can decide then. So both agents get to the house, and they have the discussion again there. He's like, I think I'm going to, I don't know if I want to consent. And the cop does the classic, well, you can revoke consent, but we're going to stay right here, and we're going to go get a search warrant, and we're going to get the machine anyways. So the guy goes, okay, go ahead. And in the case, the court opinion said that was not a threat. And the reason was because when you simply state what the legal process is, which is what they could have done, it's not a threat. They were just stating a fact. Like, sky's blue and I can go get a warrant. Like, it's just the normal course. So again, when something's seized and all your agents, if I'm in Massachusetts, 8 armed agents are standing there, heavily armed, and they ask for consent, that's the aspect. Yes?
What is your take on the admissibility in court of live forensics evidence? That is, when instead of doing like a seizure of computer, performing a full analysis of the data, you just connect remotely to a live machine, and you collect evidence from there. So you don't have full chain of custody and that kind of stuff.
Okay, which aspect? The question is a question going towards the aspect of the admissibility of the forensics done on a machine. I'm kind of maybe not understanding. And you're saying connecting it and actually running the forensics in court live as it's happening right there? No. Running the forensics on it and then having someone testify to as running the forensics. I sat through a couple of the forensics presentations. They were talking about products and possible problems with them. Is that what you're referencing?
It's kind of the same. That is, traditionally in forensics, you just seize a drive and you perform do an image of it, and you just analyze it, and through that you maintain a very clear record, and you
And you're raising a question of chain of custody, how good they're doing the forensics, how much they're noting it. Again, this is going to come and be very prevalent for both civil cases and criminal cases. It's becoming very prevalent in civil cases for the metadata that you can grab from criminal cases. The aspect is expert testimony, is it pharmaceutical, Maribel versus Dow Pharmaceutical. It's a standard. Now, this comes back to, and there's a lot of cases out there in terms about doing forensics. And while you're doing forensics, particularly in civil litigation, while you're doing it, was the plaintiff's expert and the defense attorney, sitting there side by side when they're doing it. You've got, in the civil cases, doing the full expert case on it, sharing your results with the other side, taking the depositions, going back and forth. So as part of that, from a civil aspect, as doing a forensics aspect, how comfortable I am with that evidence being put in. Scientific evidence is very interesting. The idea and the standard behind it is that an expert witness is supposed to help enhance the knowledge of whatever is the subject to the jury. It's got to be credible in the field, recognized from that, and again, add to the jury. Clearly, what you folks do for computer forensics is a specialty that is required, because as I go back to my first statement, you've got to explain it at a third grade level so people can understand it at a first grade level. Civil case, okay? All right, I have 3 coins left. I need someone to stand up and put their hand up on this one. In a civil case, plaintiff versus defendant, experts, who's going to win? Guys, come on. It doesn't depend. The person with the most money who can hire the best expert is going to win. All right? So, I'm sorry, what was just set up in front, if I heard correctly? I heard it. The DNA case, the famous DNA case that came on, that you're talking about, a murder case with DNA evidence that comes in. You get an expert, an expensive expert who knows his stuff forwards and back. You stand a greater chance because you're going to diminish what that other expert does. That's the same thing when you're looking at it. So as far as civilly, forensic evidence coming in, you guys are very important. Again, the attorneys have to ask very fact-specific cases. They have to be involved early to know what's going on, and you have to educate them, again, to know what's going on. Can this be done? Absolutely. I spoke before, I'm very self-deprecating at times, and I've had people say, stop being so self-deprecating. Folks, I'm not a rocket scientist. But you've seen those American Express commercials? An FMU 140 bomb fuse made by Motorola with a pitot tube that gets released as it's going down to check the airspeed going through. And if it doesn't get released because of the circuit that's in there, it won't go off and it's a dud. And the circuits are actually put in, and when they were initially put in, they were put in by hand in a factory down in Mexico. And that was the first production, the first test that we went through. And as they went through, they changed it. And now they're being machine implemented, and that caused the weakness there. So the circuits were breaking, the pitot tubes weren't going out, and the bombs didn't go off. Wow, are you a bomb expert? No, but I stayed in the Holiday Inn Express last night. I don't know stuff about bombs, but the chain reaction. So again, it's kind of like Aladdin. So I got kids again. He can be taught. I mean, we can learn, and it's your job to break it down so we can understand it. So the forensics aspect of it, you've got to break it down. And that's the thing. Criminally, the criminal aspects of forensics, imaging of that nature. Personally, I think that's a tougher standard to bear and have to deal with. And part of that is because of the fact that you're now talking a deprivation of your liberty as opposed to anything else on that. But there are still the same standards that they have to go through. The end case presentations that were done yesterday were very enlightening. That's why I was there. Very interesting aspects. Again, what's the weakness and what's being done? What can I attack? And while I would like to say in confidence that the job is they have to prove you guilty beyond a reasonable doubt, you ask any defense attorney, I have just got to introduce that doubt. Where can I introduce that doubt? And that's what we go with. So I noticed the time. We're going to go into some third-party consents because that's been very big. I'm going to try to go through this a little fast on this one. The materials in here I am going to try to, this material I don't get to, I'm going to bring to the forefront for when I speak at DEF CON on Friday, so if you're hanging around, so I don't give the same speech twice. And the same, you'll hear the same jokes. I apologize for that. I'm limited. Third-party consent's a big thing. It's where you've got people living in different places. This is a military case. It's a case where the defendant is going to buy a computer from his roommate. And he takes the computer, puts it in his room. They have set up a LAN in there for gaming and file sharing. And so the guy he's going to buy it from, he hasn't paid him yet. And the guy still performs maintenance on it. And of course, performing maintenance, he clicks under My Music, finds images of child pornography, and does what anybody would do, calls the cops. Cops come and arrest the guy, bring him into court, and the question is, actual authority or apparent authority? Actual authority is, hey, it's mine, I'm going to approve. Apparent authority is, well, you know, he's got common access to it. The individual who owns it hasn't done anything to restrict his access to it. He's got permission. Okay, it appears to the cops the totality of the circumstances that he can approve. So the search is good, it stands, the guy goes to jail. Now, there's a fun case that just came out called U.S. versus Andrus. And the reason it's fun is because this is also known as it's the 91-year-old doctor answering the door in his pajamas. They're investigating his 51-year-old son. Now, he lives at home to care for his elderly father. And they come, and after 8 months, nothing has happened in this investigation. So they go and do a knock and talk. And there's Dr. Andrus, opens the door, 91, standing in his pajamas. Now, they do not talk about if he's frail or his faculties or anything like that. But through the course of the investigation, and you got to remember, the doctor pays the internet bill in the house. The email address looks like it's got his initials on it. So there's some aspects for it. They say, hey, we know a couple people live here. You know, do you have access to your son's room? He says, yeah, I do, except if the door's closed or locked, I knock before I go in. And they said, can we search, the door's open, they see the bedroom, can we search the computer? They go in, they're looking at it, and then finally something, the facts I think I might have missed, but it's not clear. They stopped the search because they found out that the doctor really doesn't use the computer. And then Ray comes home, of course, and there's cops standing in there. And again, it goes back to my previous point. Can we have consent to search the computer? It's kind of like 4 cops are standing here, right here. Yeah, go ahead, on that one. So the district court looks at it from the apparent authority aspect of life. Again, going back to what was there for the investigation. On this one, at the appellate level, it starts looking good because the appellate level starts looking at computers and makes the comment that for most people, computers are the most private things that they've got. So it's starting to look good for the home team, like we're going to go in a different direction. Starts comparing to those things that we have a higher expectation of privacy in. And then I don't know what happens, but then it goes in the other direction. And they basically say, nope, we're okay on this one. By the way, they used Encase on this and got right past the password-protected files on it. And again, it's an interesting aspect what courts are willing to look at and what they're not, what they recognize. On this one, they said password protection is not so pervasive as that we expect cops to know it's there. In this day and age, my question becomes, if I'm a ne'er-do-well kind of individual, which files on my computer am I really going to password protect?